Thank you for joining Mayor Brown's Global Receivables and Supply Chain Finance webinar today. This is the fourth in a series of 9 webinars that will run through November to keep our clients up to date on developments and noteworthy issues. If you're joining us today, it surely means that you are among a select society of dedicated people willing to tune in to a legal training program in the middle of August. Since you've decided to spend your time with us, we will try to make your investment worthwhile. My name is Massimo Capretta. I'm a partner in the firm's finance department, and one of my responsibilities here at Mayor Brown is to help look after our supply chain finance team in the United States. I have a number of counterparts around the firm, and if you have been dialing into this series, you've also heard from some of them. Our team here at Mayor Brown is currently made up of over 50 professionals spread across Europe, Asia, and the Americas, and we are very proud to be a trusted advisor to a number of the world's leading market participants in this space. If you are a client of Mayor Brown, you probably know that for several years now, our supply chain finance team has hosted a series of live client events in New York, London, Hong Kong, and Singapore to discuss current events and developments in the supply chain finance market. In 2019, over 600 outside guests attended these programs. Unfortunately, we've had to postpone those events this year because of the current health situation, but we hope that, circumstances permitting, we'll be able to get together again soon in the new year. In the meantime, we hope you'll find these programs useful. A description of the remaining programs in our series is contained at the end of the slide deck. Before we begin today's webinar, I'm going to cover a few administrative matters. First, at the bottom of your screen, you'll notice there are multiple buttons you can use. Answers to some common technical issues are located in the Help section. Also, in the resource list is a PDF of today's slide deck. This program is going to be recorded, as we normally do with these programs. In a day or so, we will be sending you an email with a link, which you can use to listen to the webinar again or share it with your colleagues at your leisure. The recording will also be posted on our website for future use. Finally, and although so far in this series we haven't had the best success with this, we do plan to save some time at the end for questions. To submit a question electronically, please use the Q&A button. If we don't get to your question during this webinar, we will make every attempt to follow up with you afterwards. With that done, I'm going to introduce today's speakers. Firstly, joining me today is Angie Chia. Angie is a partner in our Singapore office and has more than 20 years of experience in trade finance. Angie has spent a considerable time both in-house and at private law firms and is widely regarded as one of the leading trade finance lawyers in Asia. Also joining me today is my colleague Bianca Soares. Bianca is a senior transactional lawyer here at Mayor Brown, and these days she spends the majority of her time on receivables and payables work. In addition to her regular duties, Bianca has an extensive amount of experience working on these types of transactions in Latin America and regularly works with our colleagues in Brazil, Mexico, and elsewhere. Finally, we're also joined today by Ravi Amin, who is a senior associate in our London office and a talented member of our London team. The subject of today's program is the 5 most common questions about receivables and payables financing through a platform. You should know that in order to create these questions, we went through a sophisticated AI-enabled selection process, which pretty much mostly consisted of me writing down some questions from our clients over a couple-week period in July. But these are the actual questions we've received, and we did try to answer them to the best of our ability. And finally, before we start, I do have a preliminary note that I'd like to make, because I think it's really important for a program like this, especially given that there's a wide array of people on this webinar. And what I want to say at the front is that the intent of this program is not to downplay or criticize or to say anything particularly negative about this space or the platforms out there or the administrators who administrate them. That is absolutely not our intent. I think there's a wide recognition here at the firm, at least amongst our team, that these platforms serve a very important role, both for investors and for suppliers, especially in the middle market and SME space, and obviously they offer technologies that are unique sometimes or that are innovative, and we're absolutely not looking to have this program be about a repeated series of criticisms. Our intent here was to try to provide some education and make sure that everyone's speaking the same language and on a common ground. So we hope that we'll achieve that at the end. And speaking of common language, Ravi, why don't you take us through a couple of preliminary slides to set the tone?
Thanks very much, Massimo. So, yes, before we get into the substantive issues, we thought it'd be useful to set out some context. In this webinar, we intend to use the terminology that the Global Supply Chain Forum has advanced to create some consistency in use of terminology in the market. So, for those not familiar with the Global Supply Chain Forum, it's made up of a number of trade bodies, including the ICC, the International Chamber of Commerce, and BAFT. So when we refer to a buyer in this webinar, we're referring to the corporate that is procuring goods and services and making payments to the suppliers, rather than, for example, referring to debtors or obligors, which may be terms you've previously used or heard. When we refer to sellers, we're referring to the supplier of goods and services. And it's also important to add here that we're focusing primarily on two structures or variations of these structures, which many of you will be well aware of. But to summarize, the first is the payables finance structure, which is a buyer-led structure within which sellers, so suppliers, in the buyer supply chain are able to access finance by, typically means of receivables purchase. The technique provides the seller of goods or services with the option of receiving the discounted value of receivables prior to their actual due date, and typically at a financing cost which is aligned with the credit risk of the buyer. And the payable continues to be due by the buyer until its due date. The second is the receivables discounting structure, which is a seller-led structure, where sellers of goods and services sell individual or multiple receivables to a finance provider at a discount. And this slide has a couple of great diagrams setting out the basic payables and receivables discounting structure and how it operates. Again, many of you will be familiar with it, may have heard it called something else, including within your own institution, and seen variations of them. We will touch on some of those in this webinar. So moving on, what do we mean when we refer to platforms? Essentially, we mean online portals pursuant to which payables finance and receivable discounting programs are operated. And with the ongoing digitalization of finance and trade finance, these platforms provide a digital interface where receivables can be uploaded, data and reporting shared, contracts signed, and ultimately finance provided. As Massimo mentioned, there are a variety of platforms in the market, all of which might operate slightly differently, but they typically include those platforms which are what we would consider pure platforms, in the sense they provide the base technology to allow sellers of receivables and finance providers to directly link up to sell receivables without the involvement of the platform administrator. There are also, on the other hand, platforms where the platform administrator takes on an active execution role, in that not only does it provide the base technology, but it also finances the receivable itself, or through a special purpose vehicle that the platform administrator controls. The finance provider in those circumstances will then fund the platform administrator or the SPV, whether through an onward sale of a receivable, a participation, or some other means. When proceeding, I guess it's important to add that when proceeding to provide financing using the platform, finance providers will be invariably guided by a variety of factors, including structure, practicality of use, risk appetite, availability, diligence, etc. And as a global receivables finance and payables finance team, we've assisted our clients, both on the finance provider side and platform administrator side, tackle those issues. And in this webinar, we'll explore some of these as part of the common questions. And I think that's a good segue for me to hand over to Angie and Massimo to take us through the first of those common questions.
Thanks, Ravi. I think maybe, and at the risk of being a little too basic, I mean, I think the most common question we get at the beginning is basically, what am I actually buying or funding or acquiring? And that's actually a lot more complicated than you would imagine if you don't have a lot of experience in this space. And kind of following up on what Ravi was saying on the previous slide, there are a lot of different things as a funder that you can actually come away with in one of these structures. So obviously the most basic is, and we've tried to divide this up into two very broad categories because frankly I'm very fond of creating very broad and artificially over-inclusive categories. But I think in this particular slide it'll be helpful. I mean, essentially what you can acquire is on one hand a direct right, and whether that's a receivable or something else, essentially you yourself, the funder, are directly facing the seller. And you're probably entering into some sort of agreement with the seller. And, you know, that is clearly one construct. And the answer to what you're acquiring is essentially what the seller has, right? However, on the other side of the ledger, and what tends to be also very common, or just as common, is that you're getting some sort of other right with someone intermediating, and that can take a lot of forms too. It can take the form of a participation or assignment. It can take the form of some sort of right or assignment or participation, not from the program administrator itself, but from an entity that the program administrator has created, as Ravi was saying. Or it can also be a lot more complicated and take the form of some sort of note instrument or some sort of issuing financial instrument that comes out of the structure. On those, just very quickly we'll mention, and this is way beyond the limited amount of time that we have, but I will mention at least, and I'm a U.S. lawyer, so I'll mention at least in the U.S. context, that those types of structures where you're getting some sort of, not a pure pass-through, but a note or a bond or something, they raise a lot of potential securities law issues in the U.S. as well, including things like registration and risk retention. So if you're dealing with that kind of stuff, obviously you don't need to talk to us, but you really should talk to somebody. And then the last thing I'll mention on the payable side, a question that always comes up is, are you getting direct rights only as to the underlying receivable from the seller, or are you also getting something from the buyer as well? And that can take a lot of different forms, but that comes up all the time in pass-through structures like participations. By definition, it doesn't come up in structures where you're getting some sort of instrument from like an SPV or something, because by definition that's like a pooling and aggregating vehicle. So you're probably not going to get anything other than maybe potentially some sort of security interest. But it's definitely a thing that we look for on structures like this, and we try to make sure that the client has a very clear understanding of what it is they're actually buying. Angie, what did I get wrong?
Not so much what you got wrong, but it's just a question of going down to one level down. Some of the structures that we've seen, and there are really quite a number of structures out there, and the basic question that we ask is there a receivable? You shouldn't always assume that you are actually purchasing a receivable, because if the structure is such that the receivable is paid off or extinguished, then what rights are you acquiring? Is it still a trade payable in its place, or has it transformed into a loan? So you do also have to take into account certain FX regulations that may be relevant depending on how it's structured. Do you know whether performance actually has occurred, and what are your risks in terms of timing of when you are purchasing the asset, if it's really there? In terms of the receivable, is it identifiable? to the sufficient level that you can actually purchase it and enforce it. Is it the sale of a whole or a part of a receivable? There are certain implications from different jurisdictions, whether it's a beneficial assignment. Some jurisdictions don't recognize the concept of equitable or beneficial assignments. Is it a sale with or without recourse? Is the receivable encumbered? Must it be registered? We will cover asset due diligence later on in the webinar, but it's something that you have to be aware of. And are you buying an encumbered asset or not? What is the jurisdiction that's in play? Does it recognize the concept of an undisclosed or an equitable assignment? There are lots of questions and implications to a finance provider that they do have to think about. And it's really a question of the interplay between the platform and the jurisdictions and the terms and conditions that are applicable. So Massimo, did I miss anything out?
No, but I will mention, because we don't have it on the slide, and it might be of interest since you touched on it briefly, we do have a program coming up in this series, I think, which may be the next one, covering some foreign law issues, which I think will expand on some of the things Angie was mentioning. So if you have any interest, I do encourage you to participate in that one. So I think we've belabored this one enough. Ravi and Bianca, why don't you cover the next one?
And on this point of what am I getting or what am I actually buying, Massimo, there are also platforms that only sell instruments or negotiable instruments such as bill of exchange and draft. And in these specific type of program, they have their own set of issues that you should worry about and kind of research and what you're getting. Certain countries, for example, would not accept certain electronic document instruments in electronic form, but it will require physical form, delivery of a physical form document. And they also might have issues with documents that are signed electronically, so they might require wet ink for the document to be valid and enforceable as a negotiable instrument. And these sometimes present challenges to the parties involved, because if the document has to be signed by wet ink, they have to travel around the world, sometimes in cross-border transactions, and time is money, and people would not want to do that. There are concerted efforts nowadays to kind of change some of these rules. Certainly in the United States, we are seeing this movement, although it hasn't really changed so far. And in fact, similar to what Massimo was saying, we're going to have a detailed discussion on these issues in an upcoming webinar that is part of this series. And so, for those interested, please tune in on September 16th when we're going to have a discussion about this specific issue. And going forward with what platforms can offer, you also have platforms that might offer programs that have no receivables. Certain programs do not involve the sale of receivables by the seller. The finance provider in this case would advance funds to the seller on behalf of the buyer, essentially extinguishing the buyer obligation vis-a-vis the seller. And then the finance provider would seek reimbursement from the buyer. There are issues around that too, what type of accounting treatment parties are looking for, and if, that complies with what you're looking for. And if not, there are many drivers for this type of transactions that, parties may be interested in. But, this can change all over the world. It's different from client to client. So I don't know, Ravi, have you seen any of the structures where receivables are financed without actually being sold?
Yeah, thanks, Bianca. Yes, we have. So instead of acquiring ownership rights to a receivable, we've seen in the UK recently innovative payables finance structures come across our desks where the finance provider gains a contractual subrogation right to step into the seller's shoes. And I guess one of the advantages of such a structure is that it can circumvent some of the asset level diligence requirements, for example, bans on assignments or certain negative pledges, because the receivables aren't being transferred, and so that opens up the availability of financing for the seller. I guess from a finance provider's perspective, it's important to know what the positives and negatives of that structure are. and usually whether its credit teams need certain additional approvals or diligence to get comfortable from moving away from what is a tried and trusted typical payables finance bank structure. So, for example, is separate advice from counsel like Mayer Brown needed to understand the finance provider's ability to enforce its rights, or to understand the risks if the seller subsequently assigns the receivable to a third party. Does the ownership interest mean the regulatory analysis changes? Does the lack of ownership interest mean the regulatory analysis changes, such that, I don't know, licensing or other regulatory issues need to be considered? And from the platform administrator's perspective, they might want to ensure that as part of its offering to attract finance providers and to preempt some of these concerns, they're able to provide documentation that explains how the structure operates, works, how some of the risks are mitigated. And that may potentially include reliance on memos or opinions that the platform administrator has received on the robustness of the structure. So I guess I would conclude and say it is possible for receivables to be financed without actually acquiring any ownership interest in them, and I've seen that. But it's important that the finance provider understands what substitute rights it's getting, whether that opens it up to any additional risks or benefits that wouldn't ordinarily be contemplated in the typical structure. Bianca,
For sure.
Do you have anything to add to that?
No, I think that's a great summary of what the issues could be. Why don't you come explain to us a little bit more about, what the provider can be acquiring, Ravi, on the next slide.
Thanks, Bianca. So, a few more things that should be considered when acquiring receivables for a platform is whether the finance provider has a interest in specific receivables or whether it takes a shared interest in a pool of receivables. If the finance provider is to have an 100% interest in specific receivables, provided that it's operationally possible to identify those specific receivables when the finance provider advances its funds, it should be pretty clear what's being acquired. Complexity can arise when a finance provider is offered a share of specific receivables based on the percentage of the receivable the finance provider would like to purchase, or if it's offered a share of a pool of receivables based on the finance provider's share of the overall commitment of funds available to be advanced by all of the finance providers participating. And in those circumstances, I guess it's especially important to understand how the flow of funds operate, because as we all know, cash is fungible. And an example, I guess, is if the platform administrator receives some collections in from a buyer, say £100 in part payment of a receivable, how is that £100 to be shared between the finance providers who all have a stake in that receivable? You typically would expect documentation to deal with this by creating a waterfall of payments, with the payments being distributed on a pre-agreed pro rata basis, with something else in the contract which protects in the event that the finance providers are all getting a partial ownership interest in the receivables, that governs when a finance provider can enforce directly against the buyer. And the obvious reason for that is to prevent a finance provider going rogue and enforcing its rights against the buyer in order to try and get first payment from the buyer for its share of the receivable. That would obviously disrupt the pre-agreed method of collecting receivables, which is intended to ensure the pro rata division of collections. Now, that can also give rise to additional questions of its own regarding privity of contract. For example, in the sort of partial ownership structure that I mentioned, what if another finance provider did enforce its rights against the buyer before it was contractually entitled to do so? Are all the finance providers party to the same contractual agreement such that they could sue that defaulting finance provider? Or would the platform administrator be the only person with privity of contract with all the finance providers? And if so, can the finance providers require the platform administrator to take action against the defaulting finance provider? And it's obviously important, these are all questions, and it's important to review the documentation to understand the options available, to understand the risk being assumed. And I mention this because we've had a real-life example of a fintech putting in place a platform of this nature where specific receivables were to be part purchased by multiple investors. And we had to work through some of these issues with them because these questions will be asked by the finance providers. The same types of issues actually arise when considering a finance provider's enforcement rights against the seller and the buyer. So in a structure that Massimo and Angie explained, where the platform administrator acts as intermediary, the finance provider may obtain rights by way of participation, where its only sort of contractual rights initially are against the platform administrator and not any other party. And those structures, I guess, can include rights of participation where the finance provider has a contractual interest in the receivable pending an elevation trigger. So a trigger where it will be able to get an ownership right in the receivable and direct rights against the seller. It can also include structures where the finance provider receives a day one ownership right in the receivable, but a restriction on any enforcement rights against the seller or the buyer or any other party until an elevation trigger has occurred. And it's really important to understand, in order to understand the rights that a finance provider is acquiring, to review those elevation triggers carefully. We've seen agreements where the elevation trigger is open-ended, such that the finance provider can elevate itself into the platform administrator's position vis-a-vis certain receivables at any time. Alternatively, it might be limited to certain triggers only, and so a finance provider might consider, does it need certain credit rating-based triggers to mitigate the risk it takes on the platform administrator? But in either event, we'd expect the platform administrator to, on the occurrence of an elevation trigger, to use commercially reasonable efforts to execute documents to ensure elevation can be achieved. But ultimately, it would be for the finance provider to understand whether that elevation would give rise to any other issues, including any licensing or regulatory type issues, depending on the location of the seller and buyer. So, as you'll appreciate, there are a variety of structures that will materially impact what the finance provider is acquiring and what rights it acquires, and therefore what risks it takes. And I'll hand over to Massimo and Angie at this stage to discuss one of the prime risk considerations, which is the insolvency or credit risk that the finance provider takes on the platform administrator.
Thanks, Ravi. And that's right. I mean, I think, insolvency or maybe even pre-insolvency credit risk is, a question we deal with in these types of structures all the time. And it's a good risk to consider because, it really gets to the heart of what the underlying risks are, not just on some of the stuff that you were just talking about, but some other issues too. And, when we get asked this question, once again, it really flows into two separate categories because insolvency or credit can affect the transaction structure differently depending on, going back to the first slide, what is it that the finance provider actually has. And, if the finance provider has a direct right, or if the finance provider is entering into a relatively simple transaction where, you might be doing, like a true sale-style participation or some other type of interest that is giving you, direct access to the underlying economic rights, and subject to the next column, maybe, the bankruptcy analysis can be relatively simple. If, on the other hand, and that's why the second column is a lot longer, that's not the case, and it's not a relatively simple structure, and you're dealing with either, a platform where the platform administrator is actually taking a very active role and is intermediating themselves in the process. So, most obviously if they're handling cash, or if there's some sort of funding vehicle involved that's run by the administrator, the questions get much more complicated. And, and we find at least, and Ravi, I find at least that, the vast majority of the questions in that context really ultimately get to cash management. Essentially who's holding the cash, both cash coming in from buyers if it's a payables finance structure, or cash coming in from sellers if it's just a receivables finance structure, or really just cash coming in from funders, right? Because most of these platforms have a lot of different funders. And, it's hard to say anything really definitive for a couple of reasons. One, because the structures used in these programs vary a great deal, from program to program, but also because insolvency law varies a great deal from country to country. So, the way that the insolvency law is set up in the United States has very little to do with the way the insolvency law is set up in even other, Western countries. And I think it's hard to say anything conclusive, but I think overall, when you look at sort of the continuum of risks, the answer to the question is yes, there could be a material amount of insolvency risk or credit risk if the platform is actually handling the cash movements. And that risk will depend on a number of factors. One, is the cash in accounts that are controlled by the platform, or is there more of a trust structure where there's a third party involved, or the accounts are in places that are not really subject to the insolvency risk of the platform. How does the cash move? Are the accounts handling lots of commingled obligations? So is the platform funneling cash from lots of different programs into the same account, or is it funneling cash from lots of different funders through the same accounts? Does the platform have direct access? So are they pulling their own fees out of these accounts at the same time? All of those things are going to impact one way or another what the overall risk is and what the likelihood of being exposed to a platform insolvency or distress situation are going to be. And really then another issue that kind of goes along with that is how much trust or faith the funder has in the platform. Is there some sort of backup servicer or backup oversight on the platform and its understanding or its calculation or movements of cash, or is it really a structure where really the funder is really relying on the platform administrator completely? And there's nothing necessarily wrong with that, but it's definitely something you want to consider depending on who the platform administrator is. Angie, you want to touch on this a little bit too?
Yeah, thanks, Massimo. I think fundamentally the financial institutions within our audience will be familiar with this process of dealing with outsourcing. And whenever you deal with outsourcing, you must understand the nature and extent of risk arising from this outsourcing arrangement. Now, ultimately, whether or not the platform amounts to an outsourcing of a critical or material operation of the financial institution, it's best to take that position that it is an outsourcing and do the full due diligence and ensure that you know what exactly you're buying, where is the cash going, and how is the cash going to be dealt with. I think the whole bankruptcy of Wirecard has just sort of highlighted these concerns again, and we do need to be aware in this new age of platforms that there are many variations out there, and we really do need to have a fresh set of eyes when we look at the variations out there. So totally agree with you and what you said, Massimo.
Thanks, Angie. And moving on to the next slide, one thing we thought it'd be important to discuss, because I think there's a little bit of confusion out there generally about these topics, and also because it's a question that comes up all the time, is the concept of bankruptcy remoteness. Because there are a lot of platforms out there that have their own funding vehicles, and it's important to understand a little bit about the terminology, because people throw around this term a lot, and I think sometimes if you dig down a little bit, you see there's a lot of variation. So when structured finance lawyers, at least, talk about bankruptcy remoteness, what we really mean is that an entity is extremely unlikely to ever become insolvent. And usually that's done through a number of vehicles. I mean, there's some corporate formalities that are good to have, independent directors and the like. But, fundamentally what we look at least in that space, is that the entity is constructed in a way that it is essentially impossible for it to have creditors that would cause it to become insolvent. That's why, for example, in a different context in securitization, SPEs exist for a single transaction, so that essentially the only creditor of the SPE is the funder. So, by that regard, and because, there are mechanisms in place to make sure that the entity stays solvent financially in the normal course, we can sort of say, yes, it's remote, because there are no risks out there that could potentially arise. And I think sometimes that gets muddled a little bit in the supply chain space, because, for example, if you have an entity, which is very common in this space, you'll have a special purpose funding company that will exist, whose purpose it is to go out and fund assets, whether they're single program assets or whether it's more of an aggregating entity, and then that entity will turn around and transfer or put out assets to funders, either program specific or asset specific, or maybe more of a pool type structure. And we struggle a little bit with these types of entities around this question, because in a way it's one of those things that is sort of a non-thing, because by definition, that example I just gave, that company is dealing with potentially dozens, hundreds, thousands of counterparties, hundreds of sellers, or multiple buyers, multiple funders. Any of those entities could have a dispute that would involve that entity. And by definition, that's going to make it very hard for that entity to truly be bankruptcy remote. And so, there are things that can be done to mitigate that risk, if it's a risk that the funder is actually concerned about. And, for example, you could make sure that the entity's contracts are such that they have non-petition language in all of their contracts with sellers, for example, that would restrict them from causing the entity to be insolvent. And that's enforceable in some places. You could, if it's a structure that allows for it, the funder could focus very clearly on making sure that whatever interest they're getting from the entity is done, on a true sale basis or some equivalent, where, they're not really exposed to the funding entity's insolvency risk. But those are all things that are going to vary structure to structure, and that are going to vary transaction to transaction. And, some structures are just going to, it's not going to be possible to do that given, the underlying assets or the way the program is set up. And I think in those, really what we focus on is just making sure that the client, which, if they're a funder, understands that, that's an inherent risk, and that they've accounted for it and priced it into the transaction. And when we're advising, the platform, we just try to make sure that they're sensitive to that issue, and that they understand that, of course, if you're a funder, the absolute worst thing you want is to be in a position where, if the platform itself does fail, that they come out as an unsecured creditor, for reasons that, at least to us, relatively obvious, that, a lot of these platforms are pretty thinly capitalized. So, as a funder, you're going to be really concerned about that, and we do try to help, or, advise our platform clients to try to make those risks as minimalistic as possible. But I think that's all I want to say on this slide, and I've of course gone over the time I want to do a lot. So I'm going to hand it over to the next slide.
That's right, Massimo. On the topic of mitigation, on the next slide, we talk about what level of diligence will the platform administrator perform on the sellers and buyers. And due diligence is a tool for risk management and risk control. It's an exercise that goes to the question of how do I know that all the information that I'm receiving in respect to the seller, the buyer, the asset, and et cetera, is legitimate, and if I'm receiving enough information to be able to assess the risk and make an informed decision. Generally, parties discuss what's feasible, as you were mentioning, Massimo, both from an operational point of view as well as from a cost-benefit point of view. They would, ask themselves, can I go on a deep dive into this, or should I focus on mainly like critical issues and documents? And so, the parties also analyze, who is in the best position to control that risk or to take that risk. So the timing of the diligence, they could do this in the beginning of the relationship or on an ongoing basis, and all of that is going to be measured against, the amount of receivables you might have, the size of the program, and et cetera. And so type of information that you might see, and it depends very greatly depending on the platform that you're talking about. Every platform would have its own, standards. Hopefully, all with a minimum standard that makes the sellers, buyers, and funders comfortable. But the information that you might get could be financial information on the status of the sellers, and that could be given in financial reports, so audited or not. You might have corporate or lien searches or corporate diligence, and that goes into like authorizations of officers dealing with the program and signing documents. There will be KYC of customer, at least in the United States. That's something that is parties really focus on. Is unavoidable, and so they would know, who they want to know who they're dealing with, the parties they're dealing with, and who is behind the platform and the platform provider. Because obviously doing business with parties that you might not know well can lead to unintended consequences, associated with the way the parties deal their business or who they are associated with. There's AML, ABC sanctions, things that the parties generally go through and worry about. Lien searches, you might want to know, whether there's prior liens on the assets that you're buying. Do you need releases for that? Registration, depending on what you're getting, what type of asset you're getting, do you need a filing? Certain assets, such as instruments, that might not need necessarily a filing. You might have perfection via possession, or certain assets in a participation might be automatic. You might have automatic perfection, so you don't necessarily would need a filing. Then, if you go down the one level down, the commercial contract between the seller and the buyer, parties would worry about anti-assignment provisions. Is there anything that I need to worry about there? Or the governing law of those contracts, because in certain jurisdictions, the governing law of the commercial contract would govern notice requirements and in the relationship with buyers. You might also have, opinions. I mean, if you are trying to get a true sale structure, which is not always the case, but if you are trying to get that, do you have a true sale opinion on those transactions that kind of help you make your assessment of risks and what actually you're getting? And if you are getting these true sale opinions, are you actually one of the parties that can rely on that opinion? Or are you just receiving that as a disclosure of information, but not necessarily being able to rely on that information? And then you go into other issues, for example, in cross-border transactions where you will have, sometimes regulatory issues to worry about. Certain programs, or in certain countries, I should say, supply chain finance is considered a regulated activity. And if it's a regulated activity, parties might need to have licenses to do this business in that country or to have a relationship with the seller or the buyer, depending on the type of role you have, the funder would have in this transaction. They could be the paying agent, and then they will have license requirements related to that, or not, if the platform is the paying agent. you might not have that, but then you again worry about everybody having the proper licenses and registrations that they might need. And, you might also have issues related to taxes. The payments that you're making, does that trigger any withholding tax or VAT, or, depending on the country you are, those issues might come up. And in a situation like that, as Massimo was saying, parties will make an assessment as to how much they would need, and certain parties would take a risk-based approach. And it's basically making an assessment of the risks and the mitigants that you have, perhaps mitigants in the structure or in the program itself, and then decide what are the critical information that you really need, or certain other information that might need a nice to have in terms of diligence. And assessment of that, you would be, what would be my mitigants in the structure? It could be the short tenor of the receivables, the facility amount, the amount of parties involved, credit worthiness of those parties, the track record of the platform, access to information. So all of those things could be assessed by the parties entering into the transaction, and to see whether they actually need that information, or if that's just a nice to have.
Thanks, Bianca. That's really interesting. Moving on to sort of one of the other common questions that would need to be considered is, what if the platform fails or is the subject of a cyber attack? Is the finance provider protected? So it's a slightly different direction here. And I guess the answer to the question is that the finance provider will typically take some IT risk, and the level of that risk will depend on a variety of factors. One of which might be whether the transactions can continue to be operated in the absence of the platform, in the event that the platform fails or is subject of a cyber attack. And we find that sometimes it's a risk that isn't sometimes thought about, notwithstanding the increased cyber risk that is prevalent in society. I guess the main challenge might come from the absence of documents and records. So a question that a finance provider may consider asking is, where are the documents and records related to the receivables held? If they're solely held on the platform, is there a separate backup data storage system in place which is sufficiently separate such that it won't be compromised if, in the event the platform's compromised? What are the contingency arrangements? And the answer to those questions can be crucial, because ultimately the documents and records will often contain the necessary details required in order for the finance provider to be able to evidence its rights to specific receivables and for any sort of action to be taken. There would typically at any one time be hundreds or thousands of receivables being financed at one time. So that cumulative loss of data can cause real problems, not just for the finance provider, but also the sellers, the buyers, and the platform administrators. Bianca, I'm not sure whether you had any additional thoughts on that.
Yeah, no, for sure. I mean, I think part of that is what you're saying, like, do you have some kind of continuity of service? Do you have a business service, a business continuity policy, for example? And it's just kind of being proactive about the decision of how you preserve the business continuity and how you prevent business disruption, right? So sometimes business continuity could be like just if there is a cyber attack, if there is some kind of disruption in technology, can you continue to operate despite of the serious incidents and disasters that may have happened? Or if you're not continuing, but you had completely disrupted, can you recover the operation state that you had in what time period? Can you do that in a short time period? So companies would have to think about that. They have a plan for that and assign specific personnel sometimes to be able to be ready in order to identify the resources to respond and build capabilities for monitoring, implementation, strategy, and all of that in case of some kind of disaster. And I think maybe we are in a moment where people are really testing those things. When you have, came this pandemic is one of the situations in which, planning, testing, training people might have made a difference between whether your business can continue or not. And another point that you would have to worry about is that if you don't have technology in place, since the business was based on a technology, can you, in a disruption, service everything manually? I mean, I guess if you have the capability of handling the amount of information that the technology was handling. Like, do you have the personnel that is necessary for that? Or is the program small enough that you can actually service that? In a situation where you have multiple sellers and hundreds of obligors in multiple countries, that would be very, very challenging. And so it's something that people should definitely think about. And, obviously, talking about who can control that information and who is in the best position to control that information, people, I guess the parties would have a discussion of, who would have the liability if that doesn't work. The platform would be interested in disclaiming some of the liability that, with the information that they don't control. And the funders and the sellers and the buyers would also be interested in, who's handling my information, how that is being kept in this moment of disruption. There might be other issues too, Ravi, related to insurance. I don't know if you have any perspective on that.
No, definitely, because I think one of the questions is, does the platform administrator have a cyber insurance policy in place which works hand in hand with what the business continuity policy that you've mentioned, which protects it in the event of a worst case scenario? Now, a finance provider isn't likely to have direct benefit of that insurance policy, but it might reduce some of the IT risk that is being taken, as it should allow the platform administrator to recover its systems or put in place new systems to service the receivables within a acceptable time period if you have the benefit of someone standing behind you. And there's definitely been a proliferation of cyber insurance policies in the market. I guess with all insurance policies, the excluded losses would need to be carefully analysed, but an insurance policy, when taken together with some of the factors you mentioned, can be an effective risk mitigation that can provide some comfort, at least, to finance providers and their use of a particular platform. I think that's all we wanted to say on this one. So at this stage, I'll hand over now to Massimo, Angie, and Bianca again, just to take us through the next couple of slides.
Thanks, Ravi. Well, I'm going to admit to everybody that we cheated a little bit, as you can tell from the slide, because the next slide, the last question, is what else should I be worried about, which is a couple of slides that cover about a dozen other things that we thought about adding to this presentation, but decided to put kind of in the back. So I'm going to actually move to the next slide first, even though this one covers a specific item, and then we'll talk about some of these issues on the final slide. So on this slide, we can see a lot of the other issues that we also wanted to cover in addition to the contractual agreement issue on the previous slide. And I think what I'm going to try to say, and say it very quickly because I do want to get to some of this stuff and I do want to try to save a little bit of time for questions, is that, I think in my experience as an outside advisor and, not being a financial person, I think, and it's the first item on this slide, is really what I find matters a lot in these structures, and is essentially who is the platform, and not in terms of documentation or in legal rights and things like that, which a law firm like Mayer Brown or some other firm is going to help you understand. I think the bigger issue that I find, and where we have real problems or complexities, is if the finance provider doesn't have complete faith in the platform administrator, either because they don't know them or because they don't understand the structure or because of some other reason. And I find that a lot of that, and it's a little bit of a cliche, but a lot of that is driven because, at least in my experience in this space, there is just phenomenal technology available. A lot of our clients on either side, are looking at, working with, or developing, AI and very complex algorithms and technology that is extremely user-friendly. That it really is revolutionizing what's possible, but a lot of times they really fail because they don't really understand the finance, right? And they also don't understand the drivers that are driving the finance provider, which are going to be very different depending on whether the finance provider is a fund or is a bank or some other type of entity. And that's, at least in my experience, where the clashes come. And, that's what is going to drive a lot of times whether there's success or failure. But other than that, I'm going to leave it at that. And Bianca, Angie, you want to talk about some of this other stuff?
Sure. So I think like on sanctions, AML and ABC, I mean, funders and finance providers would have different financial crimes policies across the board, and then they will vary immensely into the scope of what they need to be said, representations that they need, and also timing for those sanctions and AML and ABC to be tested. So Angie, you also have a lot of experience with that. Do you have any other thoughts on this one, Angie, on sanctions?
Sure. I think AML sanctions has always been one of the key areas, and I think from an industry standpoint, the Wolfsburg team, together with ICC and BAPT, have tried to come up with guidelines in terms of the trade finance principles, and the amendment for 2019 does cover open account transactions. So hopefully there's some level of rationalization within the market towards putting an industry standard as to who AML KYCs need to be done when you're dealing with certain open account transactions. What is also, a question of the structure, it's whether it's a committed facility or it's not a committed facility, and at which point in time you do your sanction searches and then redo your sanction searches depending on your financial crime policy. Different organizations do have different standards, and it really is something to consider when you're dealing with platforms. And I think it really boils down to, as Massimo said, knowing who your platform is and really, really understanding what they do. With the developments that we're seeing nowadays, and, down to credit analysis and all kinds of analysis, and you wonder how much AI is taking over the entire world and taking over the functions. So your regulator may probably ask you, so are your critical functions now being taken over by the platform? You think of your costs going down because, the platform's doing everything, but you also have to balance the fact that the regulator is going to ask you, okay, how much of it is going to be done by the platform? So you really do need to understand what you're getting yourself into, the nature, scope and complexity of the things that is going to be handled by the platform. And as Bianca and Ravi also pointed out, what happens if you need to have business continuity in place? How is that going? There's really, really quite a number of issues to consider. And, with all that new technology out there, it's changing so fast. You really need to have, as I said, a fresh set of eyes to look at things. And, dealing with cross-border issues, Bianca, do you want to talk about data privacy and global need to be concerned about that?
Yeah, sure. I think in recent years we have seen data privacy, data protection come to the forefront. A lot of countries have issued new regulation on that, and I guess part of it are dealing with cross-border transactions and the gathering of information, storage of information, sharing of information, especially if it constitutes personal information in certain countries, such as in Europe when they have the GDPR and things like that. That would come into play, and you need to be concerned about those things. Another thing that you touched upon, Angie, was how the partnerships that you have, how much are you relying on one platform, and whether you would want to diversify that type of partnership. Things that you would consider that too is, sometimes to integrate partnerships, you also have to integrate the technology, and that can be also costly. So some parties would prefer to be in one platform only. Some parties would prefer to have multiple options, exactly to not fall into the business continuity problem. And technology, as Massimo was saying, change and very fast. And so you would have new models and clients interested in new types of technologies, such as blockchain and things like that. But even if it's a new technology, it might not be feasible for parties to change once the relationship is really established. So you have to consider whether that it's something that you would want to be updating or not, and your clients would be interested in whether your technology is up to date and available for the new integration that they might need over the world. And you also wanted to talk about electronic signatures and enforcement of electronic documents. I hear this is very important also in Asia, so can you give us a little bit of perspective on that?
Sure, and in the interest of time, I'll just touch on it very lightly. I think as everybody goes electronic, they are assuming that e-signatures will solve all the world's problems. Just to keep in mind that the adoption of electronic signatures is not equal all across the globe. In many jurisdictions in Asia, if you have a document that includes a power of attorney, or you're dealing with negotiable instruments such as bills of exchange or drafts, they are excluded from the application of e-signature and electronic contract transactions. So we do have to structure around these issues, and it's not safe to just take one blanket position across the entire globe. I think on that, we should end on that point, because Massimo did promise that we would answer some questions. So maybe we can move on to the next slide.
All right, thank you, guys. As promised, and then I will admit we're a tad bit over, but we are going to try to get to some questions if someone's left any. Bianca, you are in charge of the question tab. Has anyone submitted anything while we've been talking?
Yeah, we have a few questions. So the first one is to Angie. Angie, are platforms prevalent in Asia?
Well, I think if you ask industry players, after the US, Asia is generally quite tech savvy. We do see quite a number of platforms here. R3, which launched the Quarter platform, is relatively famous across the globe, and they have worked very closely with the central bank regulators here in Asia. And we also have financial institutions who are actually setting up innovation platforms and dealing with all these tech platforms, fintech platforms coming up. So I would say, yes, it is really, really quite prevalent in Asia.
Right. Thank you, Angie. There's another one. I think Ravi can tackle this one. Ravi, if a receivable is assigned electronically on the platform under English law, would this affect the rights that the platform administrator or the finance provider as assignee would obtain?
Yes and no. So English law generally permits parties to sign contracts electronically, including contracts which English law requires must be in writing and or signed. However, in order to get a legal assignment of a receivable, the legislation provides that an assignment must be in writing under the hand of the assignor. So an electronic assignment may not satisfy the requirement of being underhand, and so may become an extra assignment. Now, this shouldn't cause the finance provider a big concern. Practically what it means is, in order to sue the buyer for non-payment of a receivable, the finance provider or the platform administrator, whoever is the assignee, would need to add the seller to any court proceedings. And if anyone wants a bit more detail on legal and extra assignments, the difference between them and the options, we covered this in our webinar on the 29th of July. A recording of that is on the Mayer Brown Supply Chain and Receivables Finance website, so that will provide more detail should anyone require it.
Thanks, Ravi. That's great. And I think the last one would go to Massimo. So Massimo, a lot of platforms in this space provide that, what they call a 90-second onboarding on suppliers. And we are also hearing in the internal legal that in the United States, buying receivables require the filing of UCCs and lien searches and a bunch of other things that are extremely time-consuming and costly. So who's right?
Thanks, Bianca. I really appreciate that question at the end of the program with about 30 seconds left to go. Thank you, whoever asked. No, I mean, I'm going to say this very quickly. The answer is they're both right, and also, I mean, in a way, they're both wrong. And I think what I'm going to say really fast, and then I'm going to just, if whoever asked that, if you want to give us a call, we can go through that in more detail. Is fundamentally, this comes down to a question of risk, and there is. I mean, I think I have a colleague here who always says this, and I think it's actually true. You know, while there's a ton of innovation on the technology side, and of course that's moving at light speed, in the legal world, really there isn't any, right? I mean, the law moves extremely slowly, and the rules and the procedures that were in effect, 30 years ago are still the exact same rules that are in effect today with some very minor modification. And ultimately, these questions about what you need to do at the asset level really get down to risk, tolerance, return, but there is no magic formula, and in a lot of ways, when you're considering those kinds of questions, it's really about, if you can imagine kind of like an abacus or a barbell or a scale or something, it's really a question of where on the continuum you want to be in terms of certainty, risk, return, more than, someone has figured out whatever the magic solution is, because ultimately there really isn't any. I'm going to just leave it at that and just say that if you want to talk about that in more detail, just give one of us a call, and we're happy to bore you as much as you want. So with that, I'm going to say that you've, luckily for us, and hopefully luckily for you, you've managed to waste a little over an hour with us today. That does wrap up today's program, and on behalf of Mayor Brown and my colleagues, I want to thank you for participating and listening in. I hope you found the program useful, and I hope you can join us for a future program that we'll be running in this series. You'll be receiving, if you registered for this program, you'll be receiving individual invites for those future programs as well that you can sign up to. Finally, as I mentioned at the beginning, a recording and a link to the materials for this program is going to be distributed to you over the next couple of days. Finally, thank you very much for participating once again. I think I speak on behalf of everybody. We hope that in the very near term we can see you in person, and that we'll be able to, not only talk about supply chain finance, but reconnect and find out how we've been spending 2020. Thank you very much, and we look forward to speaking with you soon.